Greetings, everybody. Welcome back to another episode of ATP Ask the Pastor. Today, someone writes in, "Dear Pastor, I have a question about the Lord's Supper. Since Lutherans use wine, wouldn't it be illegal to allow children to partake of the cup since U.S. law says that you have to be 21 years old to drink alcohol?" This is a great question. So now first, two things need to be said right off the bat. First is I am not a lawyer, and so nothing in this should be considered legal advice. Second, and more importantly, I want to personally thank Pastor Jeffrey Ahonen for his help with this topic. He is the pastor of Good Shepherd Lutheran Church in Tony, Wisconsin, and Peace Lutheran Church in Ironwood, Michigan. If you're in those areas and you're looking for faithful word and sacrament ministry, you live within driving distance of either one of those parishes, I highly recommend that you pay Pastor Ahonen a visit up there. Now, that being said, to the topic at hand. You are correct. Lutherans do use wine in the Lord's Supper because that is the element that Christ used when he instituted the sacrament. Now, does our communing of minors then put us at odds with state laws that set the minimum legal drinking age? Now, the simple answer is no, but the answer is actually quite complex how we get to that and takes us to the very heart of the religious liberty debates that are going on today. So, according to law, the minimum legal drinking age, or the MLDA, is 21 in every state. But we're dealing with a law here, and so it's never as easy as it seems. 45 states of our union have specific legal exceptions that allow minors to consume alcohol under certain circumstances. For example, we'll take the great state of Texas, since that's where I'm blessed to live. According to Chapter 106 of the Texas Beverage Code, underage alcohol consumption is allowed, quote, if it is in the presence of the minor's adult parent, guardian, or spouse, end quote. So that's fairly lax. Other states, though, are much stricter. Consider the state of Missouri. In the state of Missouri, minors are allowed to taste alcohol only for educational purposes in culinary courses. Now, that being said, about half of the states of our union provide statutory regulations allowing minors to drink alcohol specifically for religious purposes. So the question isn't as cut and dried as it may seem, and I would look into your state statutes to see precisely what your state says about this as far as exemptions go. Now, in those states that don't have an explicit religious exemption for minors to consume alcohol, or that they don't allow minors to consume alcohol with parental permission, then we would turn to the implicit exemption set forth in the Free Exercise Clause of the First Amendment of the Constitution. The First Amendment begins, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Now again, this would seem like a straightforward legal argument and an open and shut case on the case of minors partaking in Holy Communion. But again, that's not the end of the story. Because while the government cannot regulate religious belief, meaning the government can't compel you to believe something or tell you not to believe something, it can legally restrict, under certain circumstances, how that belief is expressed in civil society. And there have been several Supreme Court cases throughout America's history that have defined precisely to what extent and under what circumstances governments can restrict religious practices. Now, importantly, I think it's important to note, the government can curtail these practices, and it's on the basis of do they violate the social or the moral order. So this all started in 1878 with the case Reynolds versus U.S. And in that case, the Supreme Court ruled the government could prohibit the practice of polygamy because it destroyed social order. Now, Mormons are free to believe that polygamy is acceptable all they want. They're just not legally allowed to practice it. An example based on the Reynolds case would be that of the Mohammedan today, who believes that infidels should be exterminated, or that honor killings are one's religious duty. They're free to believe that all they want to, but they are not free to practice that, because to do so would violate the moral order and statutory law which forbids murder. Now, there's more to this, though. Later rulings, like the 1990 case, Supreme Court case, Employment Division, Department of Human Resources versus Smith, or just Smith for short, held that religious beliefs can be infringed upon to ensure compliance with other laws beyond ones affecting just the social and the moral order. Now, this means that one's religious practice doesn't excuse you from obeying other state and federal laws. And the whole thing here was if the government has a compelling interest, then it can prohibit religious practices that conflict with other laws. Now you ask, well, what's a compelling interest? Most often, it's an existing statute or a financial government interest. Now, the Smith case from 1990 was wildly unpopular with legislators on both sides of the aisle, and it was viewed by many as being way too restrictive upon religious rights. And this led Congress to pass the RFRA, the Religious Freedom Restoration Act of 1993. Now, like the Smith case, the RFRA states that the government can burden someone's religious practice if it has a compelling interest. But, and here's the big difference between the Smith case and the RFRA, the limitation of that free exercise has to be by the least restrictive means necessary, or least restrictive means available, So, now what does all this have to do with the minor at the communicant rail? Now, in those states that have an explicit religious exemption to the MLDA, then the statutes set forth clearly that their partaking is perfectly legal. In Texas, the minor will usually have a parent present with them, and therefore, as the statutory code indicates, communing with a parent present would be permitted. In the states without any specified exemptions for underage alcohol consumption, the free exercise clause of the First Amendment would then be used to defend the minor's right in partaking of the Lord's Supper. But even then, that's still not the end of the matter because the government does have a compelling interest in limiting the alcohol consumption of minors. That's for several reasons. Probably the most obvious one is drinking and driving. Now, of course, in the sacrament of the altar, you're getting a minuscule amount of wine, and it's not going to lead to intoxication. It's not going to lead to mental or physical or emotional impairment. Nevertheless, the government does have a compelling interest in the matter because it would endanger lives to have minors driving around with alcohol in their systems. So, since there is a compelling government interest, the government could attempt to burden the minor's religious practice by banning the use of sacramental wine altogether. But the RFRA states that the least restrictive means of furthering that compelling interest have to be used. And so a complete ban on sacramental wine to minors wouldn't be the least restrictive means to keep them from doing harm to themselves and to others while under the influence. And so if the government's concern is having impaired teens on the road, then there are other less restrictive means. For instance, the government could do what the state of New York has done, and that is limit the amount of sacramental wine that minors can have. They limit it to 2 ounces. The New York state law is a great balance between the government's compelling interest and the minor's right to the free exercise of his religion. Now, the RFRA ultimately then is what protects minors so that they can partake of the Lord's Supper. But it also requires that minors follow the other laws, both state and federal, about alcohol use. And since most states ban teens from driving with any amount of alcohol in their system whatsoever, this means that minors who partake of the Lord's Supper then are required to obey other state laws. Paul says all throughout his epistles, especially in Titus 3:1, be subject to rulers and authorities to obey and be ready for every good work. And so ultimately what this means is that the minor communicant should have a ride home from the divine service, even though he's not at all intoxicated, because he is bound to give Caesar obedience and follow Caesar's other laws about alcohol consumption. So this entire question at hand, and the entire subject of religious liberty for that matter, in the United States, I think is best understood from a two kingdoms perspective. God has placed us in his church and in the world under secular authority. And Christians can't choose to live just in the church so that they can snub secular authority in obedience to that. God has established the secular authority, and Christ himself has told us, render to Caesar the things that are Caesar, and to God the things that are God. And so in this, the minor renders to God the things that are God's by partaking of the Lord's Supper so that he can have his sins forgiven by receiving the true body and blood of Christ. The minor communicant then renders to Caesar obedience and honor by making sure that he has a ride home after the divine service. Great question. Thanks for the topic. We'll see you next time on ATP Ask the Pastor.